5 seconds to go. Start. The Parliament, by this special legislation, having created an expert body, being appellate tribunal to deal with matters concerning attachment, possession and confiscation, and vesting of property in the central government, it is, but necessary, that the forum should be functional and accessible to the aggrieved persons uninterruptedly. Stop. We need to impress upon the executive to take necessary corrective measures in this regard. Stop. Absent such forum, the aggrieved persons have to rush to the High Court on every occasion, which indeed is avoidable. Stop. Para. It is asked that there is no gradation of punishment depending on the nature of offence which may be committed by the principal offender and other offenders. Stop. Section 4 of the 2002 Act makes no distinction between person directly involved in the process or activity connected with the proceeds of crime and the other not so directly involved. Stop. Further, the scheduled offence may have been committed by someone else and the offence of money laundering by third person owing to being involved in the process or activity connected with the proceeds of crime. Stop. The petitioners have relied on section 201 and 212 of IPC. Stop. It is their case that this distinction is absent in section 4 of the 2002 Act, which provides that the term of rigorous imprisonment shall not be less than 3 years and extend up to 7 years or 10 years, as the case may be, with fine. Stop. This argument to say the list is flimsy and tenuous. Stop. 4, the punishment under section 4 is not in relation to the predicate offence, but offence of money laundering under section 3 of the 2002 Act is the person may be involved. Stop. The person may be involved in any one or more than one process or activity connected with the proceeds of crime. Stop. All of them are treated as one class of offender involved in money laundering. Stop. The proceeds of crime may be derived or obtained as a result of criminal activity with which the offender involved in money laundering offence may not be directly concerned at all. Stop. Even so, he becomes liable to be proceeded under section 3 and punished under section 4 of the 2002 Act. Stop. The principle of an accessory after the fact will have no application to the offence of money laundering. Stop. Suffice it to observe that the argument under consideration is devoid of merit. Stop. Para. On the basis of same analogy, it was argued that the twin conditions of bail contained in section 45 of the 2002 Act would act grossly disproportionate and illogical qua a person who is not directly connected with the scheduled offence but merely an accessory after the fact. Stop. Even this argument needs to be stated to be rejected for the same reason. Stop. Para. The above analysis, in our view, is sufficient to answer the diverse issues canvassed before us. Stop. We have attempted to extensively deal with the essential aspects to record our conclusion issue-wise. Stop. Further, we do not wish to dissect every reported decision cited before us to obviate prolixity. Stop.